You are watching Holland Estates. My name is Noah Weisberg.
And I'm Sydney Osmar.
As you can tell, Sid and I will be doing today's webcast from the joys of our house, but we're not going to let COVID prevent us from doing these podcasts. So, how you doing, Sydney?
I'm good. How are you?
I'm doing well, thanks. So today, Sid and I, we're going to talk about notices of objection when people are objecting to probate and how detailed these notices have to be. For our viewers and listeners who are out there, we'll be discussing the case of Dessisa and Demisie. It can be found on Canley, and the citation is 2020 ONSC 641. So, Sydney, I think maybe what we should do is talk about the actual content of the notice of objection, but just a tiny bit of background. It was common law spouses. They had a breakdown in their relationship. They entered into a separation agreement, which one normally does, which had full and final releases, files a notice of objection, objecting to the estate trustee's certificate of appointment. And just so we're clear before we get into the details of the notice, I see a lot of people these days confuse a notice of objection to probate, to a certificate of appointment, as opposed to notice of objection to passing of accounts. Two different things. We're talking about notice of objection when people are objecting to the probate process, which you all know now is certificate of appointment of estate trustee with or without a will. Very wordy, so we just like to use probate. So, Sydney, why don't you explain what the objector put into their notice of objection? They listed a bunch of grounds, and why don't you just go over those quickly?
Yeah, so the objector had a bunch of grounds. One was an alleged lack of testamentary capacity and or undue influence. Sort of coupled in all of that, she also made some sort of just bald assertions against the applicants, claiming that they had spoken to the police, which prevented her from visiting her ex-spouse while he was in the hospital, claiming that the applicants were behind her separation proceedings and that they had actually encouraged the deceased to separate from her, that she didn't actually understand the minutes of settlement that fully resolved her separation proceedings. So they weren't your typical objections which relate to why someone can or shouldn't be provided probate. He kind of wrapped in a bunch of other things.
And that's exactly right, Sydney. But what the judge was basically able to do was, notwithstanding all that fluff and allegation, it was really, at the end of the day, it was a will challenge based on lack of testamentary capacity, right? And so we're going to fast forward a little bit, and the applicants wanted to strike the notice of objection. We're going to get there in a moment. But there were basically two things that the judge considered as to whether the notice of objection should proceed, right? And the first thing was, did the objector adduce really any evidence about the testator's capacity?
Right. And the judge ultimately found that they failed to produce any evidence regarding the capacity. And one of the reasons was that the objector actually hadn't been in the deceased's life since 2017. So she couldn't provide any direct evidence to the deceased's capacity. So all that was really before the court on the question was what was produced by the applicants, which was letters and notes from social workers who had worked in the hospital and had records from the doctors. There were handwritten notes to the bank manager, really. So anything just to support the presumption of capacity versus anything to challenge that presumption.
Exactly. And the judge found that there was no evidence of incapacity, and there wasn't even any corroboration regarding the bold allegations and just the suspicion that the objector had. So first reason, right? No notice of objection. And what did the judge say about the minutes of settlement in regard to the separation proceedings?
Right. So for the minutes of settlement, the judge kind of made a similar finding that the objector had just, again, made bald assertions. She said that she did have a lawyer, but that the lawyer didn't explain them properly to her and she didn't understand. But on the same token, the objector didn't start or commence any professional negligence proceedings against this lawyer. And she ultimately turned to the decision, I believe, Olivieri and Sherman, which is an Ontario Court of Appeal decision, and found that when looking to the enforceability of minutes of settlement, you're not supposed to be looking at the subjective intention of the parties, but actually looking at the objective reading of the words of the minutes of settlement. And she found that the minutes of settlement were fully comprehensive, very detailed, and dealt with all of these issues, and found that they were enforceable.
Exactly. And the judge, again, they came forward and said, listen, you entered into minutes of settlement, which had expansive releases, can't later change your mind and what you entered into when you separated. So given those two real core issues, the applicants had sought to rely on Rule 25.11 to strike the pleading, the notice of objection, on the basis that it was frivolous or vexatious. And again, the judge relied on those two core things to find in the applicant's favor. So the notice of objection was struck out and the applicants were entitled to proceed with their probate application. So I think just closing, the takeaway is this. It's similar to what we see now with the courts. If you're going to file a notice of objection and commence a will challenge proceeding, you got to have something to assert that someone is incapable. You can't just file a notice of objection and hope for the best. It's the same thing that Justice Myers mentioned in the SEPA decision, where there's got to be something more than just a bold allegation or suspicion. You have to have something. So, Sydney, I'm not sure if you have any final comments.
No, I think you summarized that well.
Perfect. So I guess that concludes our podcast. Thank you for joining us today. Again, my name is Noah Weisberg.
And I'm Sydney Osmar.
Thank you for joining us on Holland Estates, and have a good day.
Thank you.